Hello again, doctors, and welcome to this week's Case Law Update. I'm Dr. Chris Rapoff of EZ QME Continuing Education, and in today's Ojeda versus Amy's Kitchen, we have a Workers' Compensation Appeal Board decision on a request by the defendant for a reconsideration of a workers' compensation judge's original ruling. The defendant contends that the opinions of the orthopedic QME be upheld as qualifying as substantial medical evidence in their opinion. In this instance, the workers' compensation judge's original rule that the QME's conclusions did not qualify for substantial medical evidence, and they provide many of the QME's statements that he made in his deposition as proof of such. This week's case is a crash course in perhaps what to do in an exam and what not to say in a deposition. As background, we have the applicant, Miss Ojeda, who's claimed that she injured her neck, bilateral shoulders, bilateral upper extremities, and bilateral wrists while she was employed by Amy's Kitchen as a senior manufacturing worker and claimed that she had a CT injury. The defendant in this case accepted the neck injury claim but denied injury to any of the other body parts that she had actually claimed in her adjudication application. Ms. Ojeda initially received treatment from her primary treating physician, and he diagnosed her with having left shoulder impingement syndrome, left wrist sprain and right wrist sprain, left carpal tunnel syndrome, and right carpal tunnel syndrome. She was then released from care and referred to her physiatrist for further treatment. And their diagnoses at the time were bilateral shoulder impingement syndrome, bilateral rotator cuff tendinosis, bilateral wrist sprain, and bilateral carpal tunnel syndrome. As the claim continued through the process, she was actually evaluated by an orthopedic panel QME at the time. He concluded that her objective factors of disability were shoulder pain and lateral neck pain, and evidence of non-verifiable radiculopathy to her wrist. And in his report, he stated, quote, "The problem is coming from the neck and the shoulder, and it is one of non-verifiable radiculopathy," and that's it. After receiving his initial QME report, the defense responded with a supplemental request and provided some additional medical records for him to review. It was a rather wordy response, but I wanted to put this in here for you so we could review it together. The doctor responded, basically the problem was cervical and not in her shoulders. Any minimal limitation of motion in the shoulders would have been from the cervical radiculopathy. There was an EMG and nerve conduction study which showed mild carpal tunnel on the right. That was misreading. That was not carpal tunnel. There was never any evidence of carpal tunnel. Ms. Ojeda had cervical radiculopathy. There was an MRI of her left wrist, and basically she had no complaints involving her left wrist, and there were very few complaints involving her left shoulder. The problem was cervical, and the cervical impairment subsumed everything else. The MRI of the right shoulder was also irrelevant in my opinion, and none of the shoulder issues of the MRI and none of the wrist issues are valid. The problem was cervical radiculopathy, and the cervical impairment subsumes all other issues. As you can see, he states a number of different objective facts here. However, he doesn't back them up by anything that would help him qualify his report and his response as substantial medical evidence. And of course, later the QME's deposition was taken, and some of its answers were alarming. And so I've included several of them, but there are actually more in the case if you would like to read that. There are some questions here. First of all, they ask, so do you feel that she never had carpal tunnel in the right wrist? And the doctor responded, well, I don't know. The doctors that saw her in early 2019 thought maybe she did, but when I saw her, she didn't. So it can come and go. Things get better, things get worse. I don't know what happened. She had previous wrist Well, she had previous wrist surgery. I never did get any records on that, so I don't know. So my answer is, I don't know. If you see the telling response here, he's not being very definitive and he's not backing up his findings or lack of findings. They continue in the deposition, and the defense asks, so what did you base your opinion on what there was no injury to the left wrist? And the QME's response is, well, I don't know. She may have had an injury. I don't know anything about it. She didn't complain of it. I don't know if she ever had an injury or not. Again, very, very non-definitive, non-descriptive, and obviously does not qualify as substantial medical evidence in that opinion. So based on those answers that the doctor provided in the deposition to the defense, the Workers' Compensation Appeals Board reviewed the records and agreed with the original work comp judge conclusion that Ms. Ojeda did indeed suffer a CT injury to her neck, bilateral shoulders, bilateral upper extremities, bilateral wrists while she was employed in Amy's kitchen. They also stated that the primary treating physician's findings were consistent, logical, and fully supported by all other treating physicians, and that these conclusions are supported by the PTP's reports, which qualify as substantial medical evidence. So there we have it. Consistency, credibility, understanding, succinct, and correct statements were made by the PTP, but they were not by the QME. I thought I would add a couple additional questions here. They asked, well, did you examine the left wrist? And the QME's response was, yes, I examined where people have complaints. She did not have any complaints of the left wrist when I saw her for the first time in December of 2020. And the defense responds and asks another question. Well, did you record the range of motion measurements for her left wrist? And his response was an emphatic no. Okay, can you see where this is going? So the next question is, the defense asks, well, why is that? Why is it that you did not do the range of motion measurements of the wrist? And his response was, well, because she had no complaints, number one. And number two, I felt the problem was cervical radiculopathy, and it fairly completely explained the process to me. And I just didn't think it was indicated. So, what did you do to base your opinion on that there was no injury to the left wrist? And his response is, well, I don't. She may have had an injury, but I don't know anything about it. She didn't complain of it, and I don't know if she had an injury or not. So as we see here, doctors, he rationalized his answers to himself, and he rationalized his answers in his report as saying, I couldn't find anything. But he didn't tell the reader the how and the why. If you're unable to find a diagnosable condition, you need to indicate that. But he said he couldn't find anything. So he was very nebulous with his answers and wasn't very succinct at all. So the defense contends that the QME is an experienced, qualified, and skilled physician, which I don't think there are any questions there about that. The defendant also contended that the QME had a reasonable medical basis for his conclusion that all of the applicant's complaints as of the date of the QME's first exam stem from a cumulative neck injury and are not attributable to pathology in the wrists and the shoulders. And the defense said they agree with that as well. So what is the question here? Well, we'll get the Workers' Compensation Appeals Board's response. I'm sure you won't be surprised at the Appeals Board response, but we'll talk about it here. They basically say that the dispute rises from the defendant's attempt to exclude the shoulders and the wrists from the case, based on the QME's opinion that, well, since the disputed body parts weren't symptomatic at the time of the evaluation, it's doubtful that they were ever injured in the first place. They are emphatic and say that that cannot be defended on that record. So they used some quotations that were from the QME's deposition that stated repeatedly that he did not know if the injury to the disputed body part ever occurred. What he does state is that Miss Ojeda, the applicant, had recovered from such an injury by the time of the evaluation if it did occur, but it was found by every other treating physician to report in this case. And they go on to say that had the defendant taken the position at trial that the disputed body part had been injured, but not necessarily presently causing disability or need for medical treatment, it might have been possible to use the QME's report to resolve the remaining issues. But since this issue was raised at trial, it had to be decided, and the QME's evidence could not be relied upon because the QME explicitly stated that he didn't know the answer to the questions that were posed. A no-no. Okay, so let's take a step back and ask ourselves, what could the QME have done differently? Well, first, I think for one, he should have examined the body parts claimed in the application for adjudication claim form. If a body part is listed, it's incumbent upon the QME to inquire about the body part in the interview and to examine the body part whether or not they claim symptoms. This could be a cursory exam, just including a visual range of motion and palpation and possible muscle resistance, but something needs to be addressed in each body part. If you do not do this, questions will be asked of you as to why you didn't complete these. So as we see in this case, the QME's report wasn't deemed substantial medical evidence because he was promptly removed from the panel as a result. Why? Because he didn't complete the request for the body parts that were claimed, and also just answers of I don't know why in the deposition and not being able to substantiate his conclusion caused this panel QME to be removed. Alrighty, doctors. Well, thank you so much again for taking the time to join me this week in this case law update. And I hope you learned a thing or two and we have a clearer understanding of our role as a QME in the California workers' compensation system. I look forward to speaking with you again real soon. And until then, take care. And I hope that you continue to prosper and strive to be one of the top QMEs in California. Thank you.